A quorum is present. The Committee on State and Local Government will come to order. Today is Tuesday, February 18. The first item on the agenda is MMB's budget overview. And we will have the presenters, the Commissioner and Deputy Commissioner, and if they're here and ready to go. Well, good afternoon. Welcome to the State Government Committee. Please state your name and you can begin with your presentation.
Great. Good afternoon, Chair Zhang and members. My name is Erin Campbell. I'm the Commissioner at Minnesota Management and Budget. With me today is Britta Rayton, who is our Deputy Commissioner. We'll start today's presentation with a brief overview of MMB and end with the Governor and Lieutenant Governor's 2025 budget and policy recommendations for our agency. MMB was created in 2009 after the merger of the Department of Finance, the Department of Employee Relations, and the Management Analysis and Development Team, which was originally located at Admin. In 2023, legislation added a long-term planning office to MMB as well. At MMB, we serve as stewards of the state's financial and human resources, and we're really focused on delivering effective services for the people of Minnesota. Our vision is a high-performing and inclusive workplace, improving the lives of all Minnesotans. And we have 5 values that guide our work: innovation, integrity, leadership, inclusion, and purpose. To achieve our mission and vision, we are driven by several priorities. We provide collaborative enterprise leadership, supporting cross-agency coordination and helping ensure state government delivers critical programs and services for Minnesotans as effectively and efficiently as possible. We provide for responsible and transparent management of the state's fiscal resources, promoting financial best practices, enhancing internal controls to safeguard state funds, and facilitating public access to the state's financial and fiscal priorities. MMB has received the Certificate of Achievement for Excellence in Financial Reporting from the Government Finance Officers Association for 38 consecutive years. We also delivered our state's 2024 Comprehensive Financial Report with an unmodified, clean opinion from the OLA. We work to reduce barriers to state employment and to improve employee engagement and experience, leading to improved employer retention. We want every team member in state government to be an integral part of the state's success, irrespective of their backgrounds or role. And I'm happy to report that we have reduced statewide employee turnover to its lowest point in over a decade. MMB centers the customer experience by putting the needs of our key partners and communities at the center of our services, policies, and oversight. Our focus on customer experience builds a culture of innovation and encourages our teams to continuously seek improvements. With approximately 360 full-time employees, our work at MMB touches every dollar, agency, and position in the state of Minnesota. From managing state dollars to recruiting and training key talent to long-range planning and more, we work across state government to support and strengthen state services to the people and communities of Minnesota. Some of the highlights of our work include delivering the twice annual budget and economic forecasts, giving decision makers the information they need to make sound fiscal decisions, coordinating the governor's budget setting process and working with the legislature to ultimately reach a positive budget outcome for the people of Minnesota, working with state agencies to expand the use of evidence-based decision making to help ensure agencies invest in programs that work. In 2024, through the work of our results management team, we helped Minnesota become one of only 2 states to receive the Platinum certification by Results for America, and one of only 7 states designated as a national leader in evidence-based decision-making. And administering interagency teams focused on improved services and efficiency through the Children's Cabinet, the Office of Inclusion, the Office of Addiction and Recovery, and the Health Subcabinet. We also oversee insurance for 131,000 state employees, family members, and retirees across all 3 branches of government, and we lead collective bargaining on behalf of the state. We set compensation and classification for 40,000 state employees and manage a job posting system that lists 500 job openings a day on average. Our labor relations team provides statewide leadership and support to state agencies on labor relations matters. To get a sense of the scope of our work, our teams at MMB issue 48,000 vendor payments a week, process 56,000 paychecks every other week. We manage more than $8 billion in public debt. During the time that I've been commissioner, we've maintained the highest bond ratings from all three major credit rating agencies. We've issued $1.7 billion in state bonds and saved the state $69 million by refinancing existing debt. And our management analysis and development team last year consulted with 52 organizations on 169 projects. MAD, we affectionately call them MAD, is a fee-for-service consulting group which provides services, supports, and solutions to fit partners in state government's needs. At MMB, we directly manage over $3.4 billion annually. A majority of that is the debt service that we pay on behalf of the entire state. In addition to that, we manage employee insurance premiums and payments to our health plans. We also have what we call a non-operating budget, which is comprised of various pass-through payments where MMB has appropriated money that we pass on to another entity. An example of this is direct aids to pensions and federal payments in lieu of taxes, which we then remit to local units of government where national forests are located. Our operating budget is very small at 2% of the total resources we manage. And this pie chart dives deeper into the 2% that we showed on the last slide and represents MMB's annual all funds $72 million operating budget. Many people don't think of MMB as an IT agency, but in fact, IT is our largest source of operating spending at 30% of total expenditures. That's because MMB administers several key enterprise resource planning systems that serve as a functional technology backbone of the entire state enterprise. The human resources and labor relations side of the house account for about 14% of our operating budget, followed by employee insurance, accounting services, and budget functions. Our many other operating functions each account for 6% or less of our operating budget. And with that, I will turn to Deputy Commissioner Rayton, who will describe our budget proposals.
Thank you, Commissioner, and good afternoon, Chair Zhang and the committee members. I'm Britta Rayton, Deputy Commissioner at MMB, and I'm joining you to present the Governor and Lieutenant Governor's 2025 budget recommendations for MMB. So the first recommendation is our agency's operating adjustment. Like you have probably seen from other agencies, the Governor is recommending funding to cover the growing costs related to maintaining our services and operations. This funds a portion of MMB's projected additional costs related to compensation, employer-paid healthcare contributions, FICA and Medicare, utilities, and IT services. As you can see on the slide, MMB has also taken actions to make sure we're operating efficiently and containing costs where possible, including reducing the physical footprint of our office space, improving automation of our statewide processes, and doing intentional work over the last year to ensure that we can retain staff because the cost of employee turnover can be significant. The next recommendation is around enhanced oversight capacity, and it's part of the Governor's anti-fraud package that we will walk through later in this hearing. But this recommendation includes 3 additional FTEs for our internal control and accountability unit. We currently have a team of 5 internal control specialists at MMB that provide tools, consult with agency partners, and then track resolution of audit findings. We certainly know that there is more work needed in this space, and these FTEs will add to the team's overall capacity to support agencies in improving their internal control environments. Additionally, this recommendation includes 4 FTE for our statewide payroll services section. And this recommendation is really in response to an OLA audit that was released last spring or summer related to retroactive pay adjustments that really highlighted the need for MMB to have additional oversight over agency payroll practices and procedures. This funding would allow for staffing to do compliance reviews of agency payroll practices and the implementation of a certification program for payroll specialists across the enterprise to ensure that all payroll specialists are consistently trained in statewide payroll processes. The recommendation also includes 2 FTE for enterprise labor relations to provide additional oversight and compliance on implementation of collective bargaining agreements. As the number of bargaining units and the volume of state labor relations work has increased, these additional staff will aid in the review of timely and accurate implementation of those collective bargaining agreements. And then finally, this recommendation includes 2 additional FTE for the Accounting Services Division at MMB to engage with our agency partners in the review and updating of all of our statewide financial management policies and procedures. Our goal here in engaging the staff whose roles are most impacted by these statewide policies and procedures is to reduce the time tax on those staff in terms of implementing those policies and procedures and create operational efficiencies. At MMB, we want to be more effectively assisting our state agencies to make sure that they can comply with statewide policies and procedures. Our next change item will generate overall savings to the general fund. So MMB was appropriated $10 million in a transition account for the Department of Children, Youth, and Families in fiscal years 24 and 25. The implementation office at MMB, which is a temporary office at MMB, has been coordinating in partnership with the impacted agencies the transfer of the work, processes, and systems to the new agency, DCYF. This recommendation would cancel $8.5 million in the DCYF transition account in FY25, and then reappropriate $6 million of that cancellation to DCYF for final transition expenses that aren't going to occur in this biennium. Those would include relocation costs to relocate the new agency. They're currently leasing space from DHS through the end of fiscal year 25, and so, the end of fiscal year 26, and then they would need to find a new location at that point. As well as additional costs related to continued migration of IT systems. The benefit of reappropriating the funds directly to DCYF instead of to MMB is that it will allow them to draw down federal reimbursement on those funds of $1.92 million. So when incorporating the federal financial participation reimbursement, this results in a total savings of $4.42 million to the general fund. This next recommendation is part of the broader initiative across the governor's budget to begin to address the projected deficit in the 28-29 biennium. This is a one-time reduction of $1.7 million in FY25. The remaining resources from the original appropriation will continue to be used to develop data disaggregation standards and practices across the enterprise. So this relates to a proposal from the 2023 legislative session, and it's an enterprise-wide effort to identify a minimum set of standard categories for state agencies to collect demographic data. This project will help ensure that Minnesota's data is consistent and will allow for effective alignment of data across programs to better understand program outcomes and effectiveness. So the work will continue, but with a reduced level of funding, returning $1.7 million to the general fund. The next recommendation is again part of the broader initiative across the governor's budget to begin to address the projected deficit in 28 and 29. In the 2023 session, a transfer was passed in law that would begin in FY 2025, and this transfer was for $450,000 each year from the general fund to a housing support account in the special revenue fund. This funding has not yet been programmed for a specified purpose. So the recommendation would eliminate that transfer going forward, saving $450,000 per year, starting in FY25. And then our final recommendation is a recommendation across all agency operating funds. This recommendation would allow agencies to uniformly carry forward unexpended non-grant operating appropriations for the second year of the biennium into the next biennium. The budget impact of this change would reduce forecast general fund cancellations in the second year of each biennium by an estimated $15 million. This change would provide agencies with an additional tool to help manage cost pressures from one year to the next, and would align the carry forward authority between the executive branch and the legislative branch. And with that, we're happy to answer questions.
Thank you, Commissioners, for your presentation. Members, are there any questions for the Commissioners? Senator Gustafson.
Hi, thank you, Mr. Chair. Sorry, I've got to find my page again. I believe page 13. It says cancel 8.5 million from current appropriation and then reappropriate that 6 million. And I think maybe you said it and I just missed it. The extra 2 million goes where? Back to general funds?
Commissioner?
Yes, and the proposal, excuse me, Mr. Chair, Senator Gustafson, the proposal actually ends up saving more than that to the general fund, because by reappropriating the dollars to DCYF directly, they're able to draw down federal participation, which is a non-dedicated revenue back to the general fund. So in total, it saves, let me get back to my notes, $4.42 million to the general fund.
Senator Gustafson?
Thank you, Mr. Chair. That was it. Appreciate it. Thank you.
Any other questions? Senator Brzezowski?
Thank you, Mr. Chair. Thank you, Commissioner Campbell and Deputy Rattan. You mentioned there's 450,000 each year that has not been programmed. In other words, I assume you haven't spent it. That's what you're saying there. Did the legislature give you too much money?
Commissioner?
Mr. Chair, Senator Drazkowski, in this case, this was related to the Tyler settlement conversation that I know took up a lot of space last year. It's, if I'm remembering correctly, this was resources that were transferred for that purpose, and with a goal of actually identifying what that money would go for later. And so from our vantage, we do not need those resources right now.
Senator Drazkowski?
Thank you, Mr. Chair. Sounds like a yes. So Commissioner Campbell and Deputy Rattan, I'm trying to remember my question now. You want additional authority or additional flexibility to be able to simply transfer money from one biennium to the other. I'm trying to remember the rest of the conversation. In other words, you want the legislature to have less control over this agency. When we've got $610 million of fraud happening in the state government over the last 6 years, and some would estimate over $1 billion, why should we give government even less? Why should we take even less control over government and give government even more authority to do what they would like to do?
Commissioner?
Mr. Chair, Senator Drazkowski, this is actually something that we're carrying on behalf of the enterprise, and so it would apply to all state agencies. And the goal here is it's recognizing that the 28-29 biennium, there will be a deficit, and recognizing that from agency operations needs there, that will be tighter, and that some increased flexibility would be needed at that time.
Senator Drazkowski?
Thank you. Thank you, Mr. Chair. And thank you, Commissioner. So have you also thought about giving additional authority to agencies to simply cut programs or decide not to spend in areas? in order to accommodate those budget deficit concerns? Or is it just more money?
Commissioner.
Mr. Chair, Senator Drazkowski, in most cases, we would need the legislature to pass legislation directing agencies to not, to no longer implement programs or to spend money on whatever programs that they have in front of them.
Senator Drazkowski.
Thank you, Mr. Chair. Thank you, Commissioner. Well, Commissioner, so you kind of get the essence of my question, my concern here. Government wants, the executive branch wants the legislature to give them more authority to spend money in ways and for purposes to prevent deficits in certain pockets during the out biennium. That's what I heard. And, you know, I can understand you wanting to have that authority. I think some of us are saying, you know, things are not going real well here in state government, Minnesota, for not only for the people in this state, but people looking from the outside in from our neighbors and other states in the union. But if indeed the goal is to give you latitude as an agency to be able to remedy projected budget scenarios that might happen, why wouldn't you also want similar authority on this to reduce spending on the spending side? So you're asking for increased ability to spend money, but not increased authority to not spend money. And so I'm not asking for a response, Mr. Chair. Members, I think in the environment we're in, for us to give across the enterprise, which I assume is across state government and all those agencies that the commissioner and deputy commissioner work with, I think the idea that we give these agencies who have not been able to keep track of the funds that we give them already, even more authority to do more things with those funds. Bad idea, Mr. Chair. Thank you.
Thank you, Senator Drazkowski. Senator McQuaid.
Well, thank you, Mr. Chair. I don't think more power should go to the executive branch to decide how money gets spent. I really think that the legislature should keep that. So I have two questions. One is specific because I appreciate you bringing up the Tyler settlement. I'm trying to remember because it was like the wee hours of the morning and we'd been in session for a long time and we talked about it in depth. But that money was to go to a legal settlement. And if we don't pay that out, what happens? Or, yeah, just tell me a little bit about what that is or what's going to happen.
Commissioner.
Mr. Chair, Senator McQuaid, this is slightly different than that.
Okay.
So those resources have been distributed. We've taken care of that. This was a separate conversation, and I believe it was related to, and it was a sort of last minute conversation, as I recall, and it was related to try to increase access to home ownership, I believe. And it was my understanding that that money was sort of being set aside and that that conversation would continue this legislative session. I don't know if that sounds familiar to you, but that is what I recall.
Senator McQuaid.
Thank you, Mr. Chair. Yes, I do recall that. Kind of, as much as one can from that wee hours of the morning conversation, but thank you for kind of bringing more of it back to me. My next question is, it's twofold. The first is there was hundreds of millions of dollars allocated from this legislature for a lot of projects that have federal matching funds. I think a lot of them went to Department of Commerce and maybe like Department of Ag and or Department of Transportation. And I guess I know many of them have been canceled. So some projects are shovel ready. Some projects are in RFP process. Some projects have already been completed and they're waiting on reimbursement. What happens to state money allocated for projects with federal matching funds when they're clawed back, withdrawn, canceled? What happens?
Commissioner.
Mr. Chair, Senator McQuaid, it would really depend on the agency's, the authorizing statute. In most cases, I would imagine that agencies would spend the available resources that they have and that those state dollars would just not be stretched as far as they could have been if not for federal funds.
Senator McQuaid.
Thank you, Mr. Chair. This kind of leads into the last question I suppose I have, which is as we go through what is supposed to be a budget-making process, I don't think we've ever had this level of uncertainty of like basic core partnership with the federal government. And so, I just had a constituent in my office who does pediatric cancer research, and his wife is a pediatric oncologist. They're worried about like children walking around with medical devices in their body and NIH funding being cut. But we also have, federal workers being fired for whatever, or laid off, data being breached, and some of the money we get from the federal government comes like July 1st, for example. Special education funding comes July 1st, it gets drawn down by districts. How do we make a budget? How are you gonna put together even a forecast when like in an hour, it could be like, just kidding, we don't have Medicaid. I guess I'm just trying to understand what level of clarity you all have to be able to say, like, here's what we could reasonably think could happen. And does massive unemployment, I think we have like 35,000 federal employees in the state of Minnesota. I think we have like 50 to 60,000 people separately who are supported by jobs that are federal grant related. And then there's like, hundreds of thousands of people who have federal contracts too. So what kind of like unemployment, uncertainty, federal partnership, how is that playing into the forecast making?
Commissioner,
Mr. Chair, Senator Mayquade. So I'll answer it in a few different parts. When we do the forecast is really based on current state law. And so the forecast will take into account current state law, and it also take into account a number of other factors that we look at, including GDP, unemployment, any number of factors that our national, federal, macroeconomic forecasters include. So unemployment would certainly be, both at the state and the national level, is something that is considered. The impact of something like tariffs, for example, is something that, to the extent that we have a sense of what that will be, that could be reflected, and in some positive and negative ways potentially. And so those are the type of things that get included in the forecast. I think that you raise a really important point about timing. We'll put that forecast out on March 6th, and the thing that I am most worried about right now is the impact, and I think probably most states, the impact of to state budgets from any reductions to entitlement programs, most notably Medicaid. That could have a very significant impact on our state budget, and because our entitlement programs, absent changes to state law, we have to figure out how to manage that. Scale matters, but that would be really challenging, in particular knowing that it would come likely sometime in April that we would get that information, so after the forecast, but before we need to put together, finalize a biennial budget. And so I think my overall answer is that we need to continue to be cautious and to maintain flexibility as we're thinking about this and not knowing what will come potentially in April around impacts of Medicaid.
Senator Mayquade.
Thank you, Mr. Chair. And we had a little bit of this conversation yesterday in Human Services, and so I've asked DHS to get me this, but it might be helpful to have this from, a larger viewpoint, because you're right, if we don't change state law, these are matching funds, right? So we're required to pay for them, and then we get money back. And so I guess it'd be helpful to know how much time would we have? So let's say it is July 1, June 1, and we find out like, okay, a bunch of folks don't have Medicaid anymore. We'd have to come back, we'd have to change state law in order to reduce the amount of spending there. We'd have to cut services for people. How much time would we have before it runs out? Because my fear is that all of a sudden they spend money that they're told to spend, but they can't run a deficit at DHS. And so then all of a sudden nobody has services because we've spent all the money that we've appropriated in that location. And I am kind of wondering that in other places too. If we don't change special education laws in the state of Minnesota, but we don't have special education funding, then what happens? And how long can districts provide special ed services? And I'm thinking solely with the committees that I'm on. But I want to know how soon until the government runs out of money is basically what I'm wondering. And if we could find a way to put a timeline on that, I think it'd be really, really helpful, because I mean, quite frankly, no one would need to cancel anything. Someone would just have to not be there to even give us money. And that is more and more the reality every single day. And so it's, you know, even without statutory changes, which aren't even required apparently to stop appropriating money to people, I'm really worried that all of a sudden we just won't have money because there's no inspectors general at any of the agencies to make sure that they're complying with the law. There's no, you know, people running our nuclear plants. Like, I'm just worried about people being there to actually administer money. When would we know, like, what dates would we know big chunks of money aren't coming from the federal government?
Mr. Chair, Senator McQuaid, so I think what I would say is there's a lot of ambiguity for us as well, and we are, for all of those same reasons, tracking this closely, and I think a lot of it depends on what happens in Congress in April, and so I think that is, like, at some point in mid-April is probably a significant milestone for us in terms of knowing what some of the impact is. It really depends what they do. You know, if it's something that's spread out over a decade, if it's, I mean, it really, you know, depends on what the legislation says. And so I think that there's a lot that we don't know yet, but we are concerned about that, and we will continue watching that. And as soon as we have some of that information, we're happy to share that with you.
Thank you.
Thank you. And any other questions for members? With that, commissioners, thank you for your presentation. Looks like we will go next to the Attorney General's office.
Thank you.
With the Attorney General. All right, Attorney General Ellison, welcome to the State Government Committee. Please state your name for the record, and you may proceed with your presentation.
My name is Keith Ellison, Keithellison, and I'm the Attorney General for the state of Minnesota. To my right is Laura Sales, who is our Government Relations Director, and she's going to help me run the slides. Mr. Chairman, thank you, and thank you to all members. I am so grateful to be able to share the work of the Attorney General's office with this esteemed committee and to talk to you about our budget requests this year. First, I'd like to just give you a sense of what the AG's Minnesota's Chief Legal Officer. The Attorney General has 4 primary duties. First, the Attorney General represents more than 100 state agencies, boards, commissions, in litigation and in other legal matters. This work is essential to the effective operation of the state of Minnesota and to protecting the interests and pocketbooks of our people. This includes defending the constitutionality of state law against legal challenges. Second, the Attorney General plays an important role in criminal prosecution, both in supporting county attorneys with criminal prosecutions and appeals upon their request, in sharing original jurisdiction in sharing original or jurisdiction over Medicaid fraud with the federal government. The Attorney General cannot initiate criminal prosecution without either the county attorney asking or the governor assigning the case. Third, the Attorney General serves on several state boards, including the Executive Committee, the State Board of Investment, and the Board of Pardons. And fourth, and finally, the Attorney General is the chief enforcer of the state of Minnesota's consumer protection, antitrust, and charities laws. Of our over 400 employees, approximately 40% are lawyers. The remainder are legal assistants, investigators, mediators, financial analysts, and support staff, all helping us fulfill our charge as an office. Our general budget fund is approximately $40 million per fiscal year, with about 82% of that going to compensation. Our office's mission is to help Minnesotans afford their lives and live with dignity, safety, and respect. Over the past 6 years, we've protected the state of Minnesota and its residents from harm. In that time, we've contributed $2.1 billion to the bottom line of both state of Minnesota and Minnesota households. This number far exceeds the legislature's total appropriation to the Attorney General's office over the same period. Over the last 4 years, the office has returned over $40 million to the state's general fund in the form of revenue and deposits of undispersed restitution funds. The office has further contributed significant amounts to dedicated funds. For example, we've reached a total of $565 million in settlements with opioid companies. $183 million of that has already been received. My office also has won an additional $81 million for the state's tobacco fund and a recent judgment that the state may be owed up to $58 million more plus interest. By successfully litigating against tobacco companies for not paying the state the full amounts they agreed to under the Minnesota's historic 1999 tobacco settlement, which the Attorney General's office continues to enforce. We also won more than $60 million for the state in our settlement with Juul and Altria over their deceptive marketing of e-cigarettes, which was the largest per capita state settlement in the country with those defendants. The amounts I just mentioned are the dollars we've contributed to the state of Minnesota. We've also contributed significantly to the bottom line of Minnesota households. This has taken many forms, but the highlights include $1.5 billion in utility costs that electric and natural gas consumers have saved because of the intervention and advocacy of the Residential Utilities Division of the Attorney General's office in rate utility cases and other matters at the Public Utilities Commission, pursuant to our mandate under Minnesota Statutes 8.33, along with representation by the Office of Department of Commerce in these matters. We've returned more than $85 million in restitution and debt relief that the office has won for Minnesotans victimized in student loan scams. Our Consumer Action Division has returned $51 million directly to Minnesotans' pockets over the past 6 years by helping consumers informally mediate and resolve thousands of complaints with businesses and other organizations and much more. This group gets from between 65 to 85,000 calls a year, and we have people at the phone right now ready to manage any calls coming in. And I would submit to the senators assembled here and all over our state that we're here to help you with your consumer and constituent complaints. These numbers, which are far from comprehensive, don't fully capture the human impact of our work. To get that, you'd have to talk to workers at the Evergreen Acres, a dairy farm in Stearns County that we allege illegally withheld over $3 million in wages from its workers and then charged them rent for housing that clearly didn't meet Minnesotans' legal standards. We sued Evergreen, won back pay and better living conditions for their workers, and stood up for the many businesses in our dairy industry who do play by the rules. Or you could talk to the hundreds of thousands of people in Minnesota living with diabetes. My office sued the big three insulin manufacturers for deceptively pricing their insulin products. After years of holding them to account in court, we recently won 3 settlements ensuring that for the next 5 years, Minnesotans will have to pay only $35 out of pocket for a month's supply of insulin. People who once had to pay as much as $6,000 out of pocket just to afford to live now have to pay no more than $420 in a given year. You could talk to the people living in housing formerly owned by Havenbrook Homes. Havenbrook was one of the largest landlords in the state, and they systematically failed to maintain hundreds of their properties, leading to truly appalling conditions: no heat, backed up sewer systems, mold, just to name a few. We sued them, won restitution and better repair policies, and got Havenbrook out of the state for good. I want to thank the legislature for its investment in our office. I really do appreciate it. Our ability to strengthen our team has helped us deliver these results and more for the people of Minnesota. In the 20 years before I was sworn in as Attorney General in 2019, the office saw a reduction in budget. Even as our state's population increased, society became more litigious, and the challenges facing consumers became more complicated. The funding we received in 2023 helped us hire 26 new legal staff who have made significant contributions across our office, strengthening the very teams that led to the work that I've shared with you today. The investment in additional staff for the criminal division has allowed us to expand our criminal prosecution for county attorneys and provide meaningful help to rural counties. By the way, all of these new prosecutors are very busy. It's worth noting, however, that even with the legislature's significant recent investments in the office, our 2024-2025 base funding still only constitutes 65% of what it was 30 years ago in the 1994-1995 biennium, after adjusting for inflation. So let me talk about our 2026-2027 budget request. For the 2026-2027 budget cycle, we have a robust set of requests that will help this office continue to do its important work. Because of limited time, I will only highlight a few. You should have a one-page document with more detailed information. Our budget requests are split into one-time requests of fiscal year 26 and an ongoing increase to our operating budget. Our one-time request is $940,000. The details of that request are in both the one-pager I've distributed and in our slides. I'd be happy to answer questions on those. I want to highlight the $250,000 needed to upgrade our primary server room in the Town Square Tower building, primarily to ensure a secure environment for our equipment, IT systems, and data. For our ongoing request, we respectfully request an increase in our general budget of $7.9 million per year. This includes a general operating budget increase, resources for salary parity, and funding for 26 new full-time equivalent positions. Salary parity is critically important, even after recent legislative investments in raising salaries at the AG's office, for which I'm very grateful. Attorneys in our office are still paid less on average than attorneys in comparable public law offices in Minnesota. Competitive salaries in the Attorney General's office are to the benefit of every Minnesotan. When our salaries are competitive, we are able to hire, retain, and promote the best talent to protect the interests of the state of Minnesota and Minnesota consumers, and do not risk losing that talent to other comparable law offices, public or private. And we're not trying to compete with Dorsey and Whitney. We know we cannot. But we are trying to compete with Ramsey County and Hennepin County. And I think that the lawyers and the staff at our office should be able to expect to get what other public law office staff get. Our requests for the 26 new FTEs would strengthen our conviction review unit, our antitrust division, and other areas outlined in the one-pager. I'd be happy to answer questions about these requests, but I also want to specifically highlight our request for 9 new staff at the Medicaid fraud unit. This federally certified unit investigates and prosecutes healthcare providers who commit fraud in the delivery of services in medical assistance program. According to a staffing algorithm of the U.S. Department of Health and Human Services Offices of Inspector General, the Minnesota MFCU, Medicaid Fraud Unit, is currently understaffed for the size of state Medicaid spending in the state. This request is for 1 attorney and 8 investigators. Importantly, 75% of the cost of these FTEs will be paid by the federal government, so this request is for the remaining 25% of the cost of the 9 FTEs. And as our state government rightfully increases its focus on fraud, and I do applaud your efforts in this area, it's important to remember that stopping fraud requires resources, a robust anti-fraud program, and experienced, talented people to staff it. Anything less is a boon to fraudsters. We hope to continue and strengthen our work in prosecuting Medicaid fraud. Mr. Chairman, thank you again for this opportunity to present to you today, and I'm happy to answer questions. And anything I don't know, Laura Sales knows.
Thank you, Attorney General Ellison. Members, any questions, comments for the Attorney General? Thank you. I just had a quick question. We had a letter of support from the Minnesota Farmers Union. Can you talk a little bit about some of the antitrust work that your office has been doing?
Yeah, let me just start with this, Senator. The United States economy is built on competition. Because of competition, we have lower prices. Because of competition, we have product differentiation. Because of more competition, we have higher wages. Because of competition, we have more products and services that Americans need. Antitrust work is very important. I can tell you that from when the Sherman Act was passed in the 1890s on up to maybe the mid-1950s and 60s, you had relatively robust antitrust enforcement, and you had that clear up until the 1980s. In the 1980s, a new economic and law theory came into being, something called like consumer welfare theory, which basically said as long, that the economies of scale would make prices cheaper for consumers, so the bigger the better sort of approach. And we really stopped doing antitrust enforcement, and that was on a bipartisan basis, sadly. Recently, we've seen nearly every industry you could imagine operate in a highly concentrated way. Certainly pork, chicken, other poultry, beef, certainly beer. Again, I just mentioned there are basically 3 manufacturers of insulin, but also in the hotel industry, cold cereal. So many industries have been allowed to just consolidate in the agricultural space, and also in the tech space. We see these things. I mean, but think about it. If you're going to go try to use a search engine to find some information, how many options do you have as you sit here? And this is an unfortunate thing. This is not, I'm not against these big businesses. They produce services and products that people need. I do believe they need some competition in order to bring down prices, in order to have more different, sort of more imaginative ways to use these services. And so competition is a good thing, and we want to be promoting it. It's also important to understand that it's not just the big national competitive things, but it's also on the local level. We have a number of lawsuits going on right now, but I'll just mention a few. One of them is called RealPage. We're suing RealPage. They use a computer algorithm to identify the rents in the area, and then they tell the subscribers, who are landlords, the maximum price they can charge without people opting out. We believe that they're the reason why rents are so high. And if you cannot get a bunch of landlords in a room and fix prices, you can't do it with an algorithm either. And so that's why we're suing them. So another lawsuit that we have is called AgriStats. AgriStats is people who produce, chicken, broiler chicken, and then also they've had other products in the past. And certain people are subscribers, generally big producers. Small producers are not subscribers. Labor's not subscriber. A lot of people are not subscribers. But what they do, consumers are not subscribers. Retailers are not subscribers. But what they do is they go to their subscribers and say, what is your labor cost? What is your input cost? What is your fertilizer cost? What are all this range of costs? And we allege in our lawsuit that they have been telling people you can raise a pack of chicken by 11 or 12 cents, and nobody's going to stop buying chicken because they got nowhere else to go. They're going to buy your chicken. And so we're pursuing that lawsuit. We're also suing Meta. This has to do with not only their monopoly position, but it also has to do with the fact that they're using addictive, manipulative algorithms to addict kids and so our antitrust work is robust. It's important. And if you want capitalism to work, you've got to have antitrust enforcement. And again, we've sued, Novo Nordisk, Sanofi, and Eli Lilly because of their conspiracy against consumers in deceptive practices and pricing. And so we made them, they know very well that it was the University of Toronto where the people who discovered insulin about 100 years ago sold the patent for $1. $1. And then these companies got a hold of the production process, conspired against the consumer, and if you're uninsured, you might be paying $1,300 a month for insulin, something you need to live. And so we sued them, and we got them down to $35. And so those are just a few examples. We're also suing Syngenta because they're linking their product that is a pesticide to other sort of products. So if you buy this, you also got to buy that other stuff, which interferes with other companies that are competing. So this sort of like linking. We're also suing John Deere because if you buy a car, you can bring it anywhere you want to get fixed. If you buy, a lot of products, you have this right to repair, which requires you to only go back to them, which we believe is an interference with the restraint of trade. I mean, it's a restraint of trade. We believe that if we win in this John Deere lawsuit, it will create a robust repair industry, and you'll be able to have people go and fix stuff wherever's closest to them, which will be faster, cheaper, and more effective. But, when you buy that combine, you're buying that whole combine, and they shouldn't be able to retain the codes for your combine to themselves and then charge you whenever you need it fixed. So we're suing them for that. So what we do is to create greater competition, which we believe leads to labor market competition and better wages, lower prices, and product innovation. So thank you for asking about our antitrust work. We're very proud of it.
Thank you, Attorney General Ellison, for that overview. I think we have a question from Senator Gustafson.
Thank you, Mr. Chair, and thank you, Mr. Ellison, for being here. I just wanted to say thank you also. It was my bill last year. I noticed that you brought in over $60 million in settlements from Juul and Altria over the deceptive marketing of e-cigarettes, which I don't think people understand what that bill did. There are highlighters, glue sticks, things that look like school supplies, and I'm just telling you all this as a high school teacher, that you really do have a tough time deciphering them, school supplies, from them being e-cigarettes. And I passed it, obviously, as a teacher and a mom of 4 kids, knowing that it would be a good idea to prevent these things from ending up in our schools. Had no idea it could bring in over $60 million. So would also like to push that last year I passed a bill that makes it illegal for gyms to hold you hostage in a gym membership. So for all of you who joined a gym in January and your gym won't let you out of it, you now have to be let out of it. So maybe another chance for another $60 million, but thank you.
Mr. Chairman, may I say, Senator, bless you for those very important consumer actions that you took. We are, the $60 million, that was against Juul and Altria. We're now suing Loon, I believe is the name of them, and we're saying that, look, if you're an adult and you want to vape, you can, but you can't use deceptive practices for kids. And you also passed a statute that said lay off the kids. So we're going to vigorously enforce that statute because you did the great work of getting it passed, and so now it needs to be enforced. And so thank you very much. And I will say, just for the record, yes, it's true that if you are a smoker trying to get off of smoking, maybe Juul can help you do that. But if you're a kid who's never smoked, it's probably going to make you susceptible to addiction. Actually, you can get more addicted. You won't get the cancer from the combustible. You won't get the cancer that the combustible brings, but you will be addicted. And so there are arguments to be used. It's a harm reduction for smokers, but it's all bad for kids. So thank you very much.
Thank you, Attorney General Ellison, for your presentation. And then we will go on to our next sorry, Senator sorry I missed you.
That's all right, no worries. Thank you, Mr. Chair. Thank you, Mr. Attorney General. Is that how we call you? Thank you, Mr. Ellison. I just want to say thank you so much for all your work around antitrust and in protecting the lives and the income of of Minnesota citizens. It is an important job, and I'm grateful. I just was sitting here thinking of how much I've read about your office in the last month, so I did a quick search, and want to note that the Minnesota Attorney General is now responding to illegal searches and rules coming from the Trump administration on immigration, on DEI initiatives, on protecting people, ensuring that they receive gender-affirming care, in challenging the authority of Elon Musk and privacy breaches, and most recently on protecting medical research funding from the National Institute of Health. I mean, it has been less than a month. How is your office managing this? How will you manage it staff-wise? I guess I'm also very grateful, so thank you. But I just wonder if you would like to comment on this barrage of issues from Washington and how you foresee being able to manage it on top of all the other work that your office does. Thank you, Mr. Chair.
Attorney General Ellison.
Mr. Chairman, Senator, it has not been easy. But what I can tell you, and I'd like all the senators to know, that nearly everything that the administration has done is doable if you do it the right way. If you want to get rid of birthright citizenship, change the Constitution. There is a lawful process to do that. But what you can't do is just issue an executive order. Bills passed through Congress, appropriated funds, authorized by Congress, the President of the United States does not have the authority to say that money that has been appropriated by Congress, passed through both houses and signed by the President, that the American people don't get to have that money. Can't do it. You can't shutter the Consumer Financial Protection Bureau, which was established by statute with an executive order. So we're just calling for regular order. If you want to do it, introduce a bill, argue the merits of your position, and see if you can pass it. But we're not doing that. We're trying, what's happening is the country's being governed by executive order. And so that's not the rule of law. So we're going to hold everyone to the rule of law. And, I will be candid with you. I'm looking for ways that we can work with the administration. Quite honestly, there's some things on antitrust that aren't that bad, and hopefully there's room to work with them on that. But whenever they violate the law, we're going to step up and we're going to say they can't do that. And so we've been using the Administrative Procedures Act, ultra vires, various legal procedures. We have won either a TRO or a temporary injunction in a preliminary injunction in every single matter we have filed. We have not lost. And we have gotten favorable outcomes from Reagan-era judges, Bush-era judges. It's clearly not legal, not just, Democratic appointees, but all. And so, again, you want to do this, do it, introduce a bill, argue it, see if you can get it passed. But that's not what has been happening. And so let me just say that it's been tough on our staff. Everybody has pulled some all-nighters in the last month. Quite honestly, it's not been easy, but people have been helping out each other, and quite honestly, states who agree with me, because of the important doctrine of common interest agreements, which is very important in Minnesota law. We've been able to collaborate with states that are anticipating litigation, and so we've been able to work together in that regard. Not all states, but some. On the gender-affirming care case, we only had Minnesota, Washington, and Oregon. Others are joining now. But, Minnesota has several hospitals and institutions. The state of Minnesota has several hospitals and institutions that provide this care. And you can't stop it just on an executive order. And so we're managing the best we can. And but quite honestly, it has not been a restful month for us.
Senator Ann Johnson.
Thank you, Mr. Chair, and I just want to say thank you again. I think it's really important work, and I can't imagine how busy you are, but I'm feeling some comfort in knowing that we have guardians in your office to help, especially with some of these issues that are most troubling. So I appreciate that. Thank you.
Senator McQuaid.
Thank you, Mr. Chair, and thank you, Attorney General Ellison, for being here. I want to echo what Senator Johnson-Stewart said, but I really want to go back to the points you were hitting on about Real Pages in particular. You know, we tend to have a lot of bipartisan agreement that the way that AI is being used, which in and of itself is pretty monopolistic, right? The people who make the chips, one company. The people who make the things that go in the data centers, like two companies. And I'm grateful to your office for your work on trying to at least protect kids from some of the most harmful pieces. But when I'm thinking about, you know, I know you were in Congress, I think, when the Consumer Financial Protection Bureau was created, and I can't think of anything more wasteful for government than to have people still being paid and employed to do a job that they're not allowed to do. But are we able as a state to pick up some of that work? Like, are banks going to bring back overdraft fees and junk fees? Are they going to be signing people up for more accounts? I mean, I'm just worried about consumers and the way in which we could be harmed, and how much can the state pick up from the CFPB not existing or not being able to do their job?
Attorney General Ellison.
Mr. Chairman, Senator, this is a very serious question you're asking. Look, the country is at grave risk. There are certain things that only the CFPB can do. Let me give you an example. So the small banks, and just about everybody in our legislature appreciates our community banks. I know I do. I know many of you do as well. Community banks do a great job. They have a regulator. They're regulated by the Fed. But the systemically important banks, the big banks, the banks that kind of helped us get into the financial crash of 2008, they're not regulated now. They're not regulated now. And so Citi and Wells and Bank of America, look, let me just say, Wells Fargo, made up of many wonderful people who work there, but it is a matter of historical record that they have been in controversy after controversy after controversy after controversy because of improper conduct that they have been held accountable for. Now there's nobody minding the store. And I don't think that that's good. And I mean, from a standpoint of just fair competition, everyone knows that, of course, regulation costs the business money, but it's necessary for safety and soundness of the system and for health and for all these things. But if I don't have a regulator and you do, then I'm literally at a competitive disadvantage. So the banks that didn't cause the financial crisis, they still have a regulator. The banks that did cause it, for all practical purposes, don't. Now, let me just tell you, it is not legal to shutter the Consumer Financial Products Bureau, Protection Bureau, which was established by statute vis-a-vis executive order. This matter is being challenged now. I suspect that the CFPB will get reopened, but here's the thing. Look, the executive branch does have the discretion as to how they're going to enforce the consumer laws, but they do not have the legal authority to simply say, we will not enforce the consumer laws. What does that mean for Minnesota? The answer, quite honestly, is no. The states cannot pick up for the CFPB. We simply, it's as if, imagine if the state of Minnesota stopped doing food stamps. Could the charitable community pick up for it all? No. There will be people doing wrong, fraudsters running amok, that we don't have the means to challenge. Just keep in mind that the CFPB is resourced like a federal agency, paid by the feds. It's not through appropriations, through the feds. And they just have the money and the resources and the reach to do things that we simply can't do. And the other thing is, and this is very important, the CFPB has a supervisory responsibility. There are things that, say, Wells Fargo did to consumers that consumers didn't know and couldn't know, and were only discovered because of the supervision of the CFPB. So if you go to one of our oligopolists, Google, you can find very quickly that Wells Fargo was paying a base play to its employees very low, and saying if you want to make more money, you got to move more accounts, you got to sell more credit cards, you got to do all this stuff, and this led to a lot of problems. Some of y'all may remember this. It was through supervisory supervision that was discovered. And Wells didn't even say, oh yeah, we do get to do this. They said, yeah, we're caught. And, they said they knew they couldn't do it and they weren't supposed to do it. But it wasn't through. Now, how do we get our complaints? People call us. One of the features of my office on the consumer protection area that we're trying to correct for is that we are a complaint-based system. But consumers don't always know that they were taken advantage of. And it's through this supervisory responsibility that we find out that bad things are happening. So both Bank of America, Wells, others. And remember, we had some bank scares recently in San Francisco, New York. It's these are serious issues. And so we can't pick up the slack because some things are mandated for them only to do, like the supervisory responsibility.
Thank you, Attorney General Ellison. Senator McQuaid. Sorry, just let you know we have one more presentation after this.
Thank you, Mr. Chair, and thank you, Attorney General Ellison. I think, everybody should have fear in their heart right now to hear the words, the big banks aren't regulated right now, but that's what's happening. And I appreciate you bringing up the supervisory thing because we don't always know that we're being, the fraud to consumers can be large, and especially when you talk about the big banks. And so, I appreciate all the work you're doing, and I appreciate you bringing this forward, but I'm terrified until that lawsuit goes in, or till there's a decision there. And I think it's important as we're talking about fraud, like fraud to consumers is real, particularly on the part of large international corporations, particularly when they're unregulated. That is the fraud I'm very, very concerned about because that's the stuff that keeps happening over and over and over. They're just plucking money out of our pockets. And if there's no one to stop them, how long will they keep going? So I appreciate you bringing that information forward, and I'm sorry that we can't do more from the state.
Mr. Chair, if I may say so, thank you for raising these issues. They're critically important, and consumers don't always know they were cheated. So say, for example, somebody calls my office and says, I bought an in-ground pool, and they didn't tell me a lot of things. They were slow. They know they're being defrauded because the service is bad. But if somebody has 7 accounts and 4 credit cards in their name that they never took out because the bank allowed it to happen, they may not know. And if they do find out, maybe their credit gets ruined, but they're not even sure how that happened. There's a lot of wrongdoing that you can't know unless there's an internal regulator keeping watch on the system. And the reason that we had Glass-Steagall, the reason we had so much financial regulation is because we need our credit system, but it can run afoul quickly. And when it does, it doesn't just hurt one household, it has a systemically bad effect. Remember, there were 4 million home foreclosures. And if your home, and if you made every single payment on your house and you never missed one and you never went into foreclosure, if you lived on the block with a foreclosure, your home value dropped. So you paid for it even though you never missed a payment. Thank you.
Thank you, Attorney General Ellison. Senator Coran.
Thank you, Mr. Chair, and I appreciate all the fear-mongering. I thought all of our members across the aisle love the pen, and I think the statement, didn't you like it? We're going to govern, we got a pen and a phone. Attorney General Ellison, I think you were in Congress when we celebrated and lauded that as a operational model. And so I think it's interesting. The greatest concern that Minnesotans should have would be the spending policies and the practices that were put in place over the last 2 years that are unsustainable. So do we need key funding? Yeah, absolutely. But this fear-mongering, I thought, is pretty entertaining. I can't wait till the next month. But as it relates to campaign finance and all campaigns finance, or I'm sorry, the Consumer Finance Protection Board, consumer finance, there are 4 other regulated bodies at the federal level, right? And so all of those things were still in place, all the financial harm that you spoke of. And even within the campaign, or the CFPB, and we share, we have no love lost for large banks, so we share in those values. But they also operated well without, I think, what the roles Congress gave them the right to set fees, right? Bring those things up, and whether abuses occur, I agree. But that's no different than here, and what we've done in this government is weaponizing and providing unlimited rulemaking authority, so many areas across the board, removing the legislature, or in this case, removing Congress from making those decisions. And that's what happened in many cases. And so we were part of it. The regulatory burden that was already stacked on financial institutions, it didn't stop any of the harms that you just claimed happened. They, in fact, were the contributing factors, major contributing factors to those things. And so I just think it's interesting, the selective outrage. I'm glad you guys have a platform for it. We have some things that we can share, right, consumer protection, and in the things that you talked about, I think Senator Gustafson talked about, gym memberships and all those things. I'm with you on all of those things. We should apply the same things to opting out of public union contracts or public union dues. We don't take the same approach to those things. So it's very selective in how we do those things. About if you agree to a grass cutting service, we've went after them viciously about auto renewals. Can't do that, but we allow it in public unions all the time. And so the selective outrage is nonstop. So we appreciate it where we can find good cause, good consumer protection laws. We love it. But this fear mongering, I think the greatest concerns we have to worry about today are Minnesota's budget process. And if there's funding changes and those types of things, we'll have to deal with it. And we all have the same concerns because there are constituents that are being served as well. So if there are cuts, we're going to address that internally as well. Yes, they should follow the law. But I also didn't see any outrage from your office when it was unconstitutional, I think with a pen, outside of the Supreme Court, fighting to ensure that Minnesota citizens weren't harmed because of an unconstitutional debt forgiveness, right? We talked about the law and order. We agree. Run them all through the law and order, right? You were the party pen and paper that loved it. Now it's pen and paper, and we should have them work through, and they should all be legal. We're on board there. We should all be legal. But this selective outrage, we got to make sure that we focus on what was done to Minnesota's voters by this legislature from a financial perspective, not only just from a business regulatory piece, but a cost to do business. So, thank you.
Mr. Chairman.
Attorney General.
So there are certain things that the good senator said that are essentially political, so I won't address those things. I will say this. I was there when the CFPB was drafted. I helped draft it. I voted for it in the House. I voted for it when it came back. I was at the signing, and I went to Congress numerous times as AG to defend the statute. And I can assure you that there are not 4 regulators to do what the CFPB does. Let me just finish. The way the law was crafted is that there were, but 4, maybe even 5, federal agencies that had responsibility for consumer financial protection. But what the philosophy behind the Dodd-Frank Act is that something that is everybody's job ends up being nobody's job. The Officer of Controller of Currency, the Officer of Thrift Management, the officer, the Fed, and many, you all had some consumer financial protection responsibility. This responsibility for consumer financial protection was concentrated in the CFPB because that's their only job and that was their sole responsibility. So it is not accurate to say that there are other federal agencies that can do what the CFPB does. That's the whole point of the Dodd-Frank Act, is that they would be collapsed into one group. I was on the phone with the several Fed presidents across the country who were saying, yeah, this is a real problem, because when the CFPB was erected, we pushed more into prudential supervision, safety, soundness, making sure that banks were adequately capitalized with Tier 1, Tier 2 capital. That's what we're making sure, the soundness of the system rather than the individual. So I just want to share that with you, Senator. I'll also say this. Look, we live in a political world. You can't take the politics out of politics. And when one side has the majority, they do what they want to do, and the other side has the majority, they do what they want to do, and that's just the way it is. But here's the thing. If something is passed through the legislature, even if you think it's the worst idea ever, it was done through a democratic process. And you got to live with it. That's us, our responsibility as Americans. You win the gavels, then you change it. Also, when it comes to our federal agencies and state agencies, rulemaking has no notice and comment requirements. Rules cannot be arbitrary and capricious. There is the Administrative Procedures Act that does give some guardrails to rulemaking. Now, again, we may not like the rules. The rules might be ill-advised and poor, but you can write a comment and say, this is a dumb rule. This is a smart rule. It's smart and dumb. Change it this way. Don't change it that way. But rulemaking itself has a process. What does not have a process is executive orders from the president. They're process-free. They don't go through Congress. They don't go through a rulemaking procedure. They just come straight out of his desk, and we all have to figure out how to deal with it. So and then let me just say on the unconstitutional debt forgiveness, I need you to help me understand what that is, because I've done a whole lot of suing of companies that do, student debt fraud, and there's a lot of it out there, and I don't recall losing a case based on our case being unconstitutional. So maybe you could help enlighten us on that one. But I will tell you that the other comments you made are essentially political. I'll leave your colleagues to manage those, but I just thought that those factual matters I would just raise.
Thank you,
Chair.
Senator Ellison.
Mr. Chair.
Senator Coran, final word.
Yep. But you just made my point from on the CFPB is we got there because of failure for other government entities, and so you described the perfect government model. When we are ineffective and we don't meet our objectives, you described in your description they were responsible for consumer protection, and they all failed. So we consolidated and grew government. We didn't shrink any of the other four, and I agree. I think there was 4 or 5 other regulated bodies. I happened to work for a large bank at the time when it came through, and yet I don't think you offloaded the governance of lawmaking to that entity of the ability to set fees. That's a congressional, that should be lawmaking. That's my issue. And then as it relates to student loans, all I'm calling out is the dual or the selective grievance of, well, we must operate we want our president, we do, to operate in a constitutional lawful environment. And the last president we had just canceled billions of dollars of student debt, and I didn't see you taking action against or calling out that for being unjust. In fact, it was celebrated. And so that's the hypocrisy that I'm calling out. Yeah, this part of it political, but almost everything in this last half of this conversation has been pure political pandering. We'd rather get to the focus on what are we going to do and how are you effective in your role in protecting our consumers. That we all share. So so we would like to agree where we agree and then and do good work. But I looking forward to month 2.
Senator Coran, were you looking for an answer? No. Thank you. Thank you.
May I thank you, Mr. Chairman, and everybody on the committee.
Senator.
Appreciate it.
Attorney General.
And more than happy to talk with folks afterwards about any of these matters.
Thank you. Thank you
you.
so much for your time. And next up, we have the informational presentation on the governor's anti-fraud package. We have our presenters, Commissioner Aaron Campbell, Superintendent Evans, the Commissioner Gandhi, Commissioner Tomes, Commissioner Jett, and the Deputy Commissioner Christensen. It looks like it'll be Commissioner Campbell first. Please state your name and you may proceed.
Good afternoon, Chair Zhang and members. My name is Erin Campbell. I'm the Commissioner at Minnesota Management and Budget, and I'm here with several of our agency partners to present an overview of the governor's anti-fraud package announced last month. As you know, the state of Minnesota provides critical services every day for the security, benefit, and protection of all Minnesotans. Minnesota is a state committed to helping people, and we're committed to providing services that improve the lives of Minnesotans. Fraud against these public programs is unacceptable. It is not a victimless crime, and it harms the same people we're trying to help with these services. As the financial stewards of these public funds, we take fraud, waste, and abuse very seriously and are committed to safeguarding public funds. As long as there have been programs aimed at helping people, there have been fraudulent actors looking to steal from those who need the most. Fraudsters have gotten more sophisticated, and our job is to stay one step ahead of them. Through executive action, budget, and policy, we are taking a holistic government approach to equip state agencies with the resources and tools to better detect fraud, take action, and investigate and hold fraudsters accountable. The items you'll hear about today fall into 3 core categories: stronger investigative and enforcement authority, better detection and oversight, increased criminal penalties. I will speak broadly to elements within each of these areas, and then my colleagues and I will provide more detailed information on specific proposals. To provide for better detection and oversight, the state would use AI to compare information and detect Medicaid payment discrepancies in real time. Strengthen EIDBI, Autism Center oversight by requiring licensing. Add internal controls and oversight capacity at MMB, and clarify the Department of Education's ability to ensure charter schools' compliance with procurement policies. The governor has issued an executive order to integrate the Department of Commerce Fraud Bureau agents into the centralized financial crimes and fraud section at the BCA, dedicated to investigating financial crimes and fraud. The proposal also adds investigatory capacity to the Attorney General's Medicaid Fraud Investigatory Unit, responsible for investigating and prosecuting Medicaid providers who submit false claims for reimbursement. And the package seeks to provide clear and expanded authority to stop payments and sanction bad actors by enabling agencies to withhold payments and from potentially fraudulent actors if there is credible allegations of fraud, prevent bad actors from getting state contracts across multiple agencies, and debar entities from receiving state funds. The governor's anti-fraud package includes proposals to create a new theft of public funds statute to increase criminal penalties by 20% compared to current law, and mirror federal anti-kickback law in the DHS space and give the Attorney General authority to pursue criminal charges. Now we'll get into the specific proposals. As we described in our earlier presentation this afternoon, the governor has proposed a range of additional investments at MMB to meet the public's expectations for our oversight responsibilities related to state finances and the state workforce. Highlighted here on the slide are 2 relevant parts of this proposal. We're eager to add additional capacity for our internal controls team, especially the opportunity it presents on the strategy to add more training and assistance with the goal of further building out a culture of compliance across state agencies. And the additional staff focused on MMB financial policies will allow us to provide better support for our agency partners and their understanding and implementation of these important statewide policies. With that, I'm going to hand the presentation over to Superintendent Evans.
Thank you, Superintendent Evans.
Thank you, Mr. Chair, members of the committee. My name is Drew Evans. I'm the superintendent at the Minnesota Bureau of Criminal Apprehension, and there's a couple of components that we wanted to highlight for you with the governor's anti-fraud package that is being presented today. When I think about fraud in general terms, and in particular with government programs, I think about prevention and compliance activities, identification, investigation of these matters, and then accountability for them. And for us at the BCA, our particular role when it comes to this are that investigation investigation accountability from a criminal perspective. This is when an individual wishes to purposely commit fraud against our state government programs that we believe they should be held accountable. One of the pieces that we have done currently under the Administrative Reorganization Authority that has been completed on February 7th is combining all of the resources that we previously had at both the BCA and the Commerce Fraud Bureau into one new financial crimes and fraud section at the BCA. Both of our entities operated different sections that did traditional financial crimes. In the Commerce Fraud Bureau case, insurance fraud and wage theft. We also conducted wage theft investigations, and then also state program government fraud. What this does is aligns all of the resources for criminal investigations of state program fraud, and then those other areas that I referenced together into one singular unit to maximize our resources and have an immediate impact and availability for them to be able to investigate these cases. As noted, it ensures that coordinated approach. It creates efficiencies, it reduces redundancies, and it allows us to have a better coordinated approach to fraud in our government programs while not losing any of the efficiencies that we had investigating some of those other crimes as well with a single stop. We've already implemented a website where people can report this to as part of the governor's executive order on this matter. Also, it requires state agencies to report suspected criminal fraud to the BCA along with the OLA so that we can coordinate with them to take an immediate approach or an immediate investigation into the matter and identify the most appropriate one to take a look at. The combined, as we noted here, will be insurance fraud, wage theft, state government program fraud, financial crimes, and fraud committed against individual Minnesotans, which we do all the time, and then also the auto theft program that was there. As part of the governor's recommended budget recommendations, the only that we're seeking for this unit is to supplement them, would be one forensic accountant to provide assistance to that work. A lot of times these are very intensive cases when it comes to examining financial records, and so this would be a complement to the work as we do those criminal investigations, and then additional funding to support 2 attorneys generals that we would contract with to support the work of this unit, but then also provide prosecutorial assistance in greater Minnesota if and when as needed. We also envision these teams or the attorney generals that would be assigned to this work as providing feedback so that when a prosecution occurs or if there's a declination related to one of these cases, that we can provide more finite feedback to the state agencies so that they can examine the results of the investigation and then make any determinations as to whether there should be any process improvements or policy adjustments, and the funding is located there. The second component of that is a new theft of public funds statute. Our theft statute is a fairly robust statute already, but it's a complicated statute. And so as we are examining this issue, this would create a new theft of public funds so it's very crystal clear exactly what constitutes theft of public funds, and defining that, as you can see, would be a very broadly focused, but focused on funding into government programs and those individuals. And this makes it clear that anybody that wishes to take advantage of government programs that you as legislators enact to defraud them in that process, that we recognize that that is a fraud not just against an individual but the state as a whole. And so we would have a new state fund. It would also make our investigative process easier. There's not so many dependencies in terms of looking at the theft statute. And then, as noted, it would increase penalties by 20% for the highest the 3 highest categories of dollar amounts, indicating the seriousness of theft of our government funds.
Thank you, Superintendent. Next, we have Commissioner Gandhi.
Thank you, Chairman, members of the committee. My name is Shireen Gandhi, and I'm currently serving as temporary commissioner for the Department of Human Services. For the DHS components of the governor's anti-fraud package, it's important to start with accurate knowledge of our program integrity work and DHS's often unknown accomplishments. We don't want to build new approaches on the back of speculation and conjecture. We need to build them on the backs of facts. A few key facts to keep in mind of where we are at DHS today. Our Office of Inspector General oversees 390,000 care providers. In the last 5 years, we've conducted 4,000 investigations, stopped payment to more than 800 providers, referred more than 400 cases to law enforcement, recovered more than $18 million a year on average, which is a return on investment of about $1.89 for every dollar spent. About 80% of the time, when you hear about prosecutions from our partners and investigations, whether they've taken place in the Attorney General's office, Bureau of Criminal Apprehension, the FBI, HHS, OIG, 80% of the time the referrals came from DHS. With that in mind, what are the challenges that we face to doing more, and how does the governor's anti-fraud proposal address these challenges? Challenge number one, the number of providers and payments DHS oversees are rapidly outpacing staff. This proposal adds staff to program integrity operations with a track record of a positive return on investment, as I said, of $1.89 for every dollar invested. Another challenge is that it's difficult to track data across agencies to take action early. Under Statute 245-095, DHS can take action when providers have been excluded by other state or federal agencies. This isn't timely enough. The proposal expands authority for data sharing to investigative and other relevant data, allowing agencies to act more quickly to protect public funds and not wait until a disqualification has taken place in another agency. Another challenge, bad actors exploit loopholes and shortcomings of the current statutes. For example, DHS may only immediately suspend a license if the license holder is criminally charged with theft for fraud against a DHS program. This proposal would expand the scope to include not only license holders, but also controlling individuals, and expand the scope to a charge of fraud or theft against any state or federal agency. The proposal would also allow for the authority to disqualify people under active investigation for fraud from holding any position of ownership, management, or control or billing for which the background study was conducted. Another challenge has been the growth in autism diagnoses, which is creating increased demand. And so the diagnoses are not a challenge, but it is a challenge because we need many more providers. And as a result, the number of EIDBI providers has grown dramatically. The need for services is great, and we want to ensure that the funding we provide is going to quality care that is serving our children well. This proposal would establish provisional licensure for EIDBI as a step along the way to full licensure. Provisional licensure gives us more tools to check controlling individuals and staff, quality of care, and billing practices. It will also give DHS the authority to investigate maltreatment and to increase the frequency of revalidation visits. Another challenge is substance use disorder billing practices, resulting in some providers providing two time-based claims that partially overlap. This proposal would align statute with guidance for time-based codes from the MDH rule and the CMS claims manual. Another challenge also is that the bad actors continue to get more sophisticated, so we need to step up our game too. This proposal leverages private sector expertise by funding a contract to conduct prepayment reviews of selected claims before they are paid. This gives us an earlier intervention we can use before payment withholds. And also to address this challenge of the increasing sophistication of bad actors, there is one other proposal for DHS that is a partnership with Minute to leverage technology to give us tools to use data in new ways. And with that, Chairman, I'd like to turn it over to Commissioner Thomas.
Thank you, Commissioner.
Thank you and good afternoon, Chair Jung and members of the committee. For the record, my name is Tarek Tomes. I am the Commissioner of Minnesota IT Services and the Chief Information Officer for the state of Minnesota. As Commissioner Gandhi just shared, we're excited to partner with DHS on this innovative program to continue adding layers of defense in Minnesota's Medicaid program. This comprehensive approach to enhancing our data analysis capabilities with leading-edge artificial intelligence and machine learning, detection and prevention methods will put Minnesota in the forefront of fighting fraud via data-driven decision-making. The request in the governor's budget proposes a proactive, scalable, data-driven approach to fraud detection and prevention using modern AI capabilities. As technology capabilities evolve, we should adopt these industry standards at the state, and this proposal represents a significant advancement of proactive, data-driven fraud prevention at the state. As the broader industry, as it relates to fraud detection and prevention approaches, has evolved from retrospective many years ago to prospective, emerging technology advances in AI and machine learning have really created a more preemptive opportunity. By enhancing the state's data analysis capabilities through the use of data warehouses, we will increase our ability to analyze data from different systems and do so proactively. This proposal also seeks to invest in market-leading tools and capabilities to proactively analyze enriched data to detect bad actors and suspicious activity. In order to ensure maximum effectiveness, a both-and approach is required. AI is a powerful tool to fight fraud, but it requires both strategic strategies for maximum effectiveness and certainly continuing to keep the human in the loop. We will continue to evolve these capabilities. The proposal is for a pilot program to use AI to flag anomalies for Medicaid providers through the Department of Human Services. This pilot is a critical first step to build this capability across the executive branch programs. With recent advancements, now is the time to do more. We have an opportunity to provide new tools and cutting-edge technologies to continue enhancing our oversight of Minnesota's Medicaid program, safeguard public funds, and establish Minnesota as a leader in data-driven fraud prevention. Just as an example, from our everyday lives, if we have suspicious or abnormal credit card transactions, generally we may receive a message from our credit card provider just asking, was this really you that had these transactions? Those are similar to the type of interactions that we want to provide to state workers that work on these programs, just to flag for them opportunities to look into suspicious activities, still keeping humans in the loop and in the center of the decision-making, but using technology to flag abnormalities or transactions that fit patterns that could be attributed or associated with fraud. The new proposal also builds on past investments made by this legislature, including this committee, and just a really big thank you for those investments as it relates to enhancing how we protect identities and the services that we provide to Minnesotans. To enhance the way state agencies manage identities of users accessing state programs. An example of that is when you sign up for a program using identity verification capabilities that make sure that the person signing up for a state program is in fact the person that they are purporting to be. Chair Zhang, members of the committee, with that, I'd like to turn it over to Commissioner Jett for the next segment.
Thank you, Commissioner Thomas. Commissioner Jett.
Mr. Chair, members, good afternoon. My name is Willie Jett, and I have the privilege to serve as the Commissioner of Education. I'd like to thank you for this opportunity to present the Minnesota Department of Education's components of the Governor's Fraud Prevention and Program Integrity Package. I'll be covering investments and enhancements we are proposing for fraud, waste, and abuse prevention by our Office of Inspector General, as well as investments in the legal team and improved oversight of the charter school sector. After I began as the Education Commissioner at the start of 2023, we partnered with the legislature to fund and set up our OIG team at MDE. In 2024, the legislature passed much-needed clarification and authority around the OIG's mission to combat fraud, waste, and abuse in MDE's programs. In 2023, the legislature also passed some critical oversight and program policies for charter schools and in the nutrition space. However, as a continuous improvement organization, we believe that more can be done, which brings me to our fraud prevention and program integrity proposals for this legislative session. First, we are proposing $550,000 annually for 3 FTEs and software advancements. Second, we are proposing 1 investigator added to the OIG team, and this position will increase the capacity of the OIG to investigate fraud, waste, and abuse, and more quickly address complaints. Third, we are proposing 2 legal counsel positions under our Office of General Counsel that will focus on nutrition in charter schools. 1 position will provide needed legal advice and support to ensure MDE is asserting maximum regulatory authority over nutrition program participants. And the other legal counsel will ensure the agency is effectively exercising required oversight of charter schools and is addressing program integrity and related challenges. Finally, we proposed funding for software advancements to aid the OIG's in-depth investigations into fraud, waste, and abuse by furthering the capacity of the office to track cases and conduct financial analysis of programs. And we're also proposing policy for our OIG and charter school program oversight. As the OIG progresses through its 2nd year, we have identified critical areas in last year's legislation to build off of. This includes expanding the OIG's jurisdiction around incidents of theft and abuse, enhancing protections for the investigation process, investigative data, and good faith reporters, improving the OIG's access to program participant records, and enhancing the sanctions MDE has available. These changes will support a more robust Department of Education's OIG to further prevent fraud, waste, and abuse, and enhance program integrity. And our final portion of this package sets further expectations for charter schools by enhancing fiscal oversight, improving transparency, and justifying need. This includes clarifications on state procurement law, requiring submission of annual charter school audits to MDE, requiring the recording and publication of meeting minutes on school websites, and market need and demand studies when schools moved or amend grades, sites, and programs. So again, I'd just like to thank you for the opportunity to provide an overview of the Governor's Department of Education's Fraud Prevention and Program Integrity Package. And we believe that these investments and policy proposals will build off the work that's already been done, especially in 2023 and 2024, and help combat fraud, waste, and abuse, and improve integrity to the Department of Education's programs. And I will now turn it over to my colleague from the Department of Administration, Ms. Stacy Christensen.
Hi, Deputy Commissioner Christensen.
Good
Please state your name, you may proceed.
Good afternoon, members. My name is Stacy Christensen. I'm the Deputy Commissioner at the Department of Administration. The proposal in the governor's budget to clarify grantee debarments would expand authority to suspend or debar grantees to include potential grantees. This is an effort to prevent entities who have not previously received state funds, but have engaged in or been convicted of debarment-worthy causes from becoming recipients of state-issued grants in the future. The causes for debarment include serious issues such as crimes like embezzlement, theft, bribery, falsification of records, among other serious convictions and violations. The proposal would expand the definition of grantee to include potential grantee. Clarifying the definition ensures the Office of Grants Management can exercise its debarment authority for existing grantees as well as potential grantees. The Minnesota Council of Nonprofits, the Minnesota Council of Foundations, and the State Grants Governance Council also support this change. Finally, the governor recommends requiring state employees to report violations of grant laws or rules. Currently, the law only encourages reporting. And that concludes my comments.
Thank you, Commissioner. And members, if it would be okay with the committee here, we're going to move on to the next presentation, the informational presentation on the Office of Grants Management. And since you're already there, we'll have you go. And we have 7 minutes left till the committee is done. but we will be bringing back all the commissioners for the presentation of the bills, if we could hold off on the questions. But we will still be open to questions if you have a pressing question ahead. But with that, Commissioner, Deputy Commissioner, please move on to the presentation. Thank you.
Good afternoon, members. Again, for the record, Stacy Christensen, Deputy Commissioner at the Department of Administration. I appreciate the opportunity to provide a brief overview of state grants and the Office of Grants Management, its structure and role. To level set, this slide provides a very high overview of the grants landscape in Minnesota. The OLA has highlighted that their audit work discovered that OGM is ahead of the curve, being one of only a dozen states that has statewide grants management policies in place. Grants are financial assistance paid or services furnished by a state agency via a third party to an eligible recipient. Minnesota has a decentralized state grants management system, which means that grant-making authority and decision-making, implementation and performance monitoring of grants lies with state agencies. State grants are regulated by state law and policy, and the requirements span the full life cycle of the grant, from pre-award through active grant to post-award and closeout. OGM has established a 13 policy framework that is maintained by the office and covers requirements for requests for proposals, conflict of interest, application review, risk assessment, grant execution, grantee reporting, monitoring, payments, financial reconciliation, grant closeout, and final evaluation. This slide shows a summary of how OGM fulfills their mission to standardize, streamline, and improve state grant-making practices and increase public information about state grant opportunities. Moving specifically into the Office of Grants Management, OGM was created in 2007 based on an OLA recommendation. It is a division within the Department of Administration that supports state agencies in grants administration. When the OLA conducted a program evaluation audit in 2023, OGM was a team of 4, 3 of which were dedicated to administering admin's own portfolio of grants. That left 1 team member to do the entirety of policy work, training, and technical assistance for the entire state enterprise. That 1 team member developed the first iteration of OGM's 13 policies, conducted numerous trainings and to both grant administrators and grant recipients, and provided technical assistance. Repeated efforts to provide funding for the office and for grants administrators generally were unsuccessful until 2023. The expanded office is now led by an enterprise grants managing director with teams focused on policy and compliance and admin's grant portfolio. As you can see from this slide, OGM is funded for 12 team members with 8 positions currently working in the expanded office. Additional positions will be filled as the office's implementation work from the 2023-2024 session continues. Before I move into the expanded compliance and oversight measures, I want to highlight that OGM is also a resource to the public seeking grant opportunities through the website min.gov grants. We would like to thank the legislature for the substantial investments made to the grants landscape during the 2023 legislative session. These investments related to additional compliance and oversight to address potential for fraud, waste, and abuse in state government programs. While state agencies also saw individualized investments related to grant making, the 2023 legislative changes provide OGM with additional oversight of state grants, including power to terminate a grant if not in the best interest of the state, and ability to suspend or prohibit grantees from receiving grants for cause. I will walk through the investments at a very high level over the next several slides. This slide highlights the Office of Grants Management's strengthened oversight authority. They now have authority to suspend or debar grantees for 3 years. It strengthens admin's authority to establish and enforce versus just proposing grants management policies. Grant agreements are not valid unless approved by the Commissioner of Administration. It authorizes admin to oversee grants management systems, and agencies must report to admin on the status of any grant upon request. Moving into grantee performance evaluations. In April 2024, admin launched a new grantee evaluation site where agencies are required to upload performance evaluations for grants over $25,000. This requirement applies to grants issued after April 1st, 2024, and agencies must upload the evaluation within 60 days after closeout of the grant. As grants are completed, agencies will soon be uploading these evaluations into the new system. This will allow other granting agencies and the public to see information about grants. And most of these grant evaluations will be posted in or by the summer of 2025. The state of Minnesota's grantee evaluation policies are aimed at helping agencies drive understanding about the benefits of grant-funded activities provided to Minnesotans. They also offer insights into the impact of agency grant-making efforts and support our responsible stewardship of public dollars. Additionally, the new statute authorizes agencies to retain funds for grant administration if the appropriation is otherwise silent. This is up to 5% for new legislatively named grants and up to 10% for new competitive grants. And as you can tell by what I have just spoken about and the additional requirements I will go through, grant making takes staff time. It takes resources to effectively administer grants to make sure that we are doing things right. So this new provision to allow for these administrative funds is essential. After the 2023 session, the growing OGM team focused its work on the implementation of the pre-award risk assessment statute, which was effective in January 15th of 2024. The work entailed expansion of policy, creation of a toolkit, and training rollout of the new requirement. These new provisions are substantial. They have definitions of grantee, which includes a political subdivision, nonprofit, or business entity, and requires granting agencies to perform a pre-award risk assessment to determine if the potential grantee could perform the required duties. It also requires certain information, including grantee history, financial statements, certification that the grantee's public officials, board members, or staff with access to grant funds have not been convicted of a felony, financial crime within the last 10 years. This slide highlights the risk assessment toolkit items. So the office created checklists, templates, flowcharts in order to allow staff within state agencies to effectively comply with these new requirements. The office also established training, which is listed on this slide, including overview of the statute and each of the detailed requirements that are included in the new provision. Finally, the agency has, a state agency will have authority not to award a grant if the agency determines that there is a risk that a competitive grantee cannot perform the duties of the grant and a statutory process is outlined. If the agency determines that there is a risk that a legislatively named grantee cannot perform the duties, there's also a statutory process outlined. And this is incredibly important because up until this time, agencies their hands were tied if a legislatively named grantee showed that there was an enhanced risk. So if the agency, with legislatively named grantees, if the agency has concerns, they must delay the award of the grant until adjournment of the next regular or special legislative session. Agencies must contact the grantee, the Department of Administration, and chairs and ranking members of the House Ways and Means and Senate Finance Committees with evidence of their concerns and reasons for not awarding. The legislature may then reaffirm the award of the grant or reappropriate the funds to a different grantee. If the legislature does not provide direction to the agency, the funds revert to the original appropriation source. Additional capacity in OGM has allowed them to expand the training offered to state agencies. OGM is rolling out more courses and platforms to enhance and expand the number of state agency employees trained on grants policy requirements, aiming for content tailored to different levels of state experience and familiarity with OGM grant policies. OGM is planning for learning pathways, diversified content, and broader access. Currently, OGM has 9 on-demand trainings on its website, 7 of which were produced in 2024. OGM is also working to make an Introduction to Grants Administration, which will be a 3-course training series available on the state's online employee training system by the end of this month. This will include 3 modules: State Grant-Making Basics, Grant Administration Overview, and OGM Grant Policies. Admin was appropriated funds to conduct a study of the feasibility of utilizing an enterprise grants management system. A consultant has been conducting its study over the last 11 months, and discussions with impacted state agencies is proceeding, followed by a convening of MMB, Minute, and other impacted agencies to discuss next steps. The grants management system feasibility study will determine if a single system is feasible. If so, it will examine available technology options, recommended changes to organization, controls, and processes, staffing and other needs, high-level system requirements, estimated costs, and an implementation roadmap. Thank you for your time. That concludes my presentation.
Thank you, Assistant Commissioner, for your presentation. We thank you for all the work you guys have been doing on trying to address these issues. And for members, looks like we will be getting some language from the revisor's office, and we will be hearing some of those legislation in our next committee. And with that, we are over time. Thank you for sticking behind with us and giving the presentation. And with that, the committee is adjourned.